The most common causes for slip and falls are outside, snow and ice. That's the most common for outside. Inside, probably the most common are cleaning companies or cleaning people who don't put warning signs out. That is and sometimes they put them out but not in the right location because they don't know or they don't realize that people are coming from one direction and then they mop the other direction, or they move the warning signs before the floor dries.
If you are injured in a slip or a trip and fall case and you sustain injuries as a result, you're entitled to be compensated for what we call pain and suffering, which is really the impact that injury has had on your life and on your ability to enjoy your life and on the activities that you do. You're also entitled to be compensated for any earnings that you've lost as a result if it affected your ability to work, and you're entitled to be compensated for medical expenses.
It is very difficult in the beginning to evaluate how much a slip and fall is worth due to the fact, we don't know what your injury is and how your injury is going to progress till later on in the case. Insurance is another factor, but usually buildings have a decent amount of insurance.
To find out how much your slip or trip and fall case is worth, contact us. Let us interview you. Let us find out what happened. Let us find out the details. Let us talk about your injuries and the treatment you received. And then we can together come to a determination as to what will be fair and appropriate compensation for you, and we can do our jobs to try to go get it for you. There's a lot of different types of slip and fall cases, and we have to look at the facts of the case to determine who's responsible. So there are slip and fall cases on premises, which can be due to a lot of different things. It could be due to leaks. It could be due to someone leaving something where they shouldn't have left it. You can have a slip and fall case on ice outside of a premises.
The responsibility of a slip and fall case, depending on what type of slip and fall case we're talking about, is usually the owner of the building. Especially if it's a slip and fall in the building, it would be the owner of the building. If there's an outside cleaning company, it could be the cleaning company. If someone else is doing work there, it could be that company.
You can have slip and falls, again, on a lot of different things. So one of the things we need to do in slip and fall cases is examine the facts of the case, find out from the client what exactly happened, determine who's responsible, and then try to make a claim against the person or entity that is responsible. The time limit that you have to file a claim depends on who the claim is against. If it's against a private owner or a private property owner, then generally the claim will be 3 years from the date of the incident. But there's a lot of slip and trip and fall cases that could be against the City of New York or a City of New York entity. Those cases only have 1 year and 90 days from the date of the incident. You really need to contact an attorney to try to find out who is responsible for what happened to you and how much time you have to make that claim. A slip and fall case can be resolved in a matter of months, or sometimes if we have to carry the case all the way through to trial, it could take a few years. It really depends on the circumstances of the case. No two cases are the same.
Average case takes approximately 2.5 to 3 years against a private landlord with if you have a slip and fall case. It is always a bad idea to file a claim, whether it be slip and fall or any other claim, without an attorney. Insurance companies deal with these type of cases every single day. They are at a total advantage, and you are at a total disadvantage if you do not have a lawyer. They know the time limits. They know how much cases are worth. They know what you have to prove and what you don't have to prove. You do not have that.
Anytime you're involved in either a slip and fall case or a trip and fall case where there is something on the ground that caused you to fall, it would really be helpful to have photographs taken right away at the scene. It's also a good idea, if possible, to call an ambulance right then and there, because that way we're able to document that you were hurt in that location, because we'll have an ambulance report that shows that it came to that location. So photographs would be helpful. An ambulance report showing that you were picked up at that location would be helpful. The names of any witnesses who might have seen what happened to you would be really helpful. Those are some really good ideas for people involved in slip or trip and fall accidents.
A lot of people, unfortunately, when they're involved in a slip and fall accident, they don't, rightfully so, when they're injured, their first thing is not to think what caused them to fall. Their first thing is they get up, either they're embarrassed so they just walk away, or if they're more badly injured, they call an ambulance or they go to a doctor. They don't investigate or look what caused them to fall. So many times, the person calls us up They said they slipped and fell. And we ask them what caused you, and they say, I don't know. And this is 2 or 3 days later, and if there wasn't a witness, or if there's not a video, we possibly or probably won't have a case because we don't know what caused them to fall. And we have to prove that somebody was at fault. Well, if it was slip and fall case, the first thing you do is look what caused you to fall. Then look around, see if, let's say somebody was cleaning, they didn't put a sign. Let's say there's a leak from a ceiling. Let's say there's an open window. You look around and you see what possibly could have caused whatever caused you to fall to be there. A lot of times I ask my clients to go back, see if there's something there, see if you can, especially let's say you slip on water. If it's a leak from a ceiling, usually it's not the first time. So there'll be ceiling damage, paint damage. If it's near a window and there was raining that day, maybe the window's open. Check, sometimes we send out investigators to check if there are witnesses or if there's a video camera. A lot of times these days, especially, there's video cameras. So then we send away or we try and get the video camera.
If your child was involved in a slip and fall or a trip and fall case, whether at school or on the sidewalk, contact an attorney to find out the rights that your child has. If there was a defective condition that caused your child to fall, your child is entitled to be compensated for that. So call an attorney, let's talk about it and find out what his or her rights are.
For slip and fall cases, you can recover against the landlord. Many slip and fall cases are against private landlords.
We've sued many landlords in slip and fall cases or trip and fall cases. Just recently I had a case where a client was in her building and she slipped and fell in the laundry room because there was a laundry machine that had a long-standing leak that leaked water all throughout the room, and she went into the room and she slipped. And that leak had been there for many, many months prior to her accident. So we are suing the landlord and making a claim for the landlord for failing to properly maintain the room in general and the machine in particular, which caused her accident. So yes, the landlord can very often be held responsible for defects on their premises that cause you to slip or trip and fall. If you are injured while you are on the job by a trip and fall or a slip and fall, you're entitled to workers' compensation, and that will allow you to recover the time that you miss from work. You'll get paid for that, as well as it'll pay for your medical expenses relating to your injuries. But you may also be entitled to a third-party claim against whatever other entity is responsible for what happened to you. So, for example, if you're at work and you slip and fall or trip and fall on a defect at work, if the landlord of the building is someone other than your employer, like if the employer leases space from the landlord, then you may be entitled to recover from workers' compensation against your employer and also have a third-party claim against the landlord for that defective condition.
If you slip and fall while you're working, then depending on who you're working for, it will depend if you have a lawsuit. It could be just a workers' comp case, where there are cases where you're an in-house maintenance worker for the building. And if you're an in-house maintenance worker and slipped and fell because your coworker was mopping, then you'll only have a workers' comp case. But let's say you work for a company that's in the building and an outside contractor is cleaning the building and didn't put the wet signs down, the warning signs, then you could have a workers' comp case plus a third-party case against the cleaning company and against the building.
You are entitled to make a claim for a slip or trip and fall that took place on private property. The owner of a property has an obligation to maintain that property in a reasonably safe condition. And if he or she fails to do that and you are hurt as a result, you have the right to make a claim against that owner.
If you get injured on a private property and you slip and fall, for instance, you can definitely have a lawsuit against the private landlord. If you're in a private residence, you can also sue a homeowner if they did something wrong and that is the reason why you fell. So if they have a leak from their ceiling or they have a leak from their toilet and you went to their house for whatever reason, whether you were called there because you work or because you're friendly with the person, then you can have a slip and fall case against a private homeowner. Trip and fall cases are similar to slip and fall cases in that depending on where it happened, either the city is responsible or a private building owner is responsible. So for a trip and fall case, if it's outside a commercial building, landlord will be, or the tenant, depending on the contract, will be responsible for the crack in the sidewalk or the raised sidewalk or any problems with the sidewalk. The city is responsible. It's a little harder, but the city is responsible. If it's a 1 or 2 family private house, the city will be responsible if they had notice.
At the Orlow Firm, we have represented many clients who've been injured in slips and falls, and also clients who have been injured in trips and falls on defective conditions. We've seen all different types of cases like that, all different types of defects, all different types of injuries, all different types of clients. And we'd love to represent you as well. So if you've been injured in a slip and fall or a trip and fall, call us, find out what your rights are, let us ask you questions to see what happened and what we can do for you. We'd love to represent you.
Recently, we have 2 clients, both work in LaGuardia Airport, working for different airlines, where they were both leaving their offices and the cleaning company did not put warning signs out, and they both slipped and fell. Different days, different times, different cleaning companies, because they're working at different parts of the airport. And they both had a workers' comp case, and they both have a third-party case. We really look out for our clients. We are very on top of the cases. I know every single case. I deal with every single client from beginning to end. We are very hands-on when it comes to our clients. Hi, my name is Brian Orlow. Call me today for a free consultation.